Hi everyone, this is Victor Martins from Martins Law. I'm an Ontario lawyer who assists clients with life's most important decisions in the areas of real estate and wills and estates law. In today's video, I will cover the 10-day cooling off period. Generally, all purchasers of new build condominium units purchased directly from a builder have the right to back out of their purchase within 10 days by providing written notice of their termination to the builder or the builder's lawyer. This right is automatically incorporated into the contract by law, and its purpose is rooted in consumer protection. It protects new build condominium buyers from being pressured or rushed into an uninformed long-term commitment regarding the purchase of a new condominium unit. Let's dive into some important points to note about this unique termination right. First, the 10-day cooling off period only starts when the buyer has been provided with copies of all of the following. First, the condominium disclosure statement. Second, the condominium buyer's guide. And third, the purchase agreement signed by the buyer and the developer. Second, the 10-day cooling off period is a right only granted to new build condominium purchasers where the purchase is made directly from the builder. The 10-day cooling off period does not apply to resale condominiums. It also does not apply to new build homes that are not condominiums. And finally, it also does not apply to assignment purchases of new build condominiums from an original purchaser. Third, the right to withdraw from the purchase agreement during the 10-day cooling off period can be done without cause and without providing the builder with any reasons for terminating. Importantly, if a purchaser terminates the agreement during the cooling off period, the purchaser is entitled to a full refund of all money paid to the builder with some interest and without any penalties. Buyers should use their cooling off period wisely because if they do not terminate the purchase agreement during those 10 days, they will be locked into a contract to purchase a condominium unit that may not be ready to be moved into until many years into the future. The following are some proposed steps that purchasers should take during the 10-day period. First, I would advise buyers to carefully read over the purchase agreement, disclosure statement, and the condominium guide to learn more important details about the proposed development and the nature of condominiums generally, and to ensure that important terms promised by the builder's sales team are reflected and incorporated into the purchase agreement. Next, buyers should retain a lawyer to review the materials so that they can be advised regarding any key terms or red flags located in the purchase agreement and other materials. Beyond reviewing and advising, lawyers in this scenario typically also draft an amendment request letter to the builder. An amendment request letter essentially says to the builder that because the buyer has the leverage of being able to walk away from the purchase agreement during the 10-day period, the buyer is requesting a handful of important amendments to the purchase agreement to give them an incentive to not back out of the deal. These amendments are typically centered around establishing or reducing caps on development charges and other fees, or granting the buyer more freedom to assign the agreement before closing, or to lease their unit during interim occupancy. The intention of the amendment request letter is to incorporate as many changes into the agreement as possible that favor the buyer prior to the cooling off period expiring. Despite their lawyer's advice, ultimately, the decision of whether to terminate the purchase agreement during the cooling off period rests with each purchaser. At Martins Law, we are committed to getting clients the most out of their 10-day cooling off periods by promptly reviewing new build condominium purchase agreements, advising clients on those agreements, drafting amendment request letters to builders, and following through with the amendment negotiations directly with the builder's lawyer. Not only is this a major financial commitment, it is an agreement that will not be finalized for many years, which makes it all the more important to have experienced counsel on your side to guide you through leveraging your termination right for contractual amendments that benefit you and putting your best foot forward during the relatively short cooling off period. Please reach out to our office for more information. Thank you for watching and have a great day.